Good afternoon, everyone. Welcome to Comasiel Carey's New Employment Laws and Updates from the Department of Labor during the Biden administration. My name is Lindsay DeSalvo, and I'll be presenting today with my partner, Mark Trapp. I am a partner at Comasiel Carey, our newest partner, and I work in both the firm's occupational safety and health practice and the employment practice. Which gives me a unique perspective, particularly based on the topic that we'll be covering today, as the Department of Labor stretches over both those particular practice areas, and the updates and changes that they've made during the Biden administration certainly spans those practice areas as well. So as a partner at Comasiel Carey, I represent and advise employers in all aspects of the employer-employee relationship, including in enforcement actions with the Department of Labor, as well as counseling and advising employers related to new rules and compliance directives and guidance that comes from the Department of Labor. And I will turn it over to Mark to introduce himself.
Hi, everybody. Mark Trapp here. I'm a partner in Comasiel Carey's Chicago office. Been with the firm almost 5 years now, and practiced with several of the other partners here for many years prior to that at a different national firm. I've got experience representing employers in a lot of different aspects of the employment relationship. I deal with labor unions and collective bargaining, handle a lot of multi-employer pension, withdrawal liability claims and analysis, and litigation involving that, and litigation involving most other employment related statutes. And I'm here to talk about some of the new DOL initiatives, and also chime in with a few updates at the end related to the NLRB. Back to you.
Oh. Thanks, Mark. So to kick things off, here's the agenda for the main topics that we plan to cover today. So the first topic that we are going to cover today is priorities of the current administration. What have they been publicizing as their priorities and focuses, in both their rulemaking efforts as well as in enforcement efforts? Recent Department of Labor regulations and regulatory changes. There's been a number of proposed regulations. There have been several final regulations that have come out during this administration. So we'll cover some of those today, the ones that we consider sort of the hot topics. Then we'll also touch on other notable efforts from the regulatory agenda. So maybe things that haven't been finalized yet, but are in the process, that we think could be significant for employers. And then finally, as Mark mentioned, he will cover significant changes from the National Labor Relations Board. So first, the priorities of the current administration. One of the things that the Department of Labor has been very vocal about during this administration is its focus on retaliation and whistleblower complaints. It's demonstrated this as well through actions it has taken and priorities it has set out. And one of the ways that we've seen this, and we actually, I participated last week in the ABA's midwinter Osha conference, and we had some representatives from the Department of Labor there. And the Solicitor of Labor actually specifically talked about the fact that retaliation and whistleblower complaints are going to be a focus of this administration from an enforcement side, as well as this initiative that I will talk about between a couple different agencies related to employment. So one of the first ways that we sort of seen this focus kind of come into practice is from Osha. Osha has hired approximately 93 whistleblower investigators recently hired, and OSHA, if you are not aware, the Occupational Safety and Health Administration is actually the agency that is charged with investigating complaints of retaliation and whistleblower complaints under 25 different laws. So OSHA is responsible for investigating a lot of the complaints that are filed under various whistleblower laws, both, the laws that are applicable to the Department of Labor and to the employment context, as well as others. In a recent decision from the Occupational Safety and Health Administration, this was explicitly, this was, I think, pretty recent, just within the last couple of days, they actually did order an employer to pay just under $600,000 for damages, wages, and attorney's fee related to allegations of retaliation. So this was an employee who filed a retaliation complaint with OSHA. OSHA investigated. OSHA determined that they had been retaliated against, and then issued this order requiring a really substantial payment. And this is something that I have not really seen happen very often related to a retaliation or whistleblower complaint. This is, a significant amount of money. So again, just sort of another example of how the Department of Labor, and in this case, OSHA specifically, is prioritizing investigation and enforcement related to whistleblower complaints. Another significant way that we have seen the priority and focus on retaliation and whistleblower complaints is a new initiative that was announced in November 2021 between the Department of Labor, the National Labor Relations Board, and the Equal Employment Opportunity Commission. They announced this joint initiative that they said would raise awareness about retaliation issues, both among workers as well as employers. The first sort of action taken related to this initiative was a virtual dialogue that the agency representatives held back in November. But it's sort of unclear what the scope of this initiative is going to be at this time, whether there is going to be, an enforcement component to it or guidance component to it. That certainly seems to be the goal of the initiative. But it's definitely coordination among these three separate agencies who have generally coordinated in the past. But, this has sort of created a priority of coordination among these agencies related to retaliation and whistleblower complaints. Another thing that I think is notable related to whistleblower cases, but really sort of enforcement actions more generally, is that the Department of Labor has also indicated that its solicitors, those are the attorneys that represent the agency, will start to get involved in cases earlier, have a part in sort of earlier development of a case, an investigation of a case. So I thought that was, interesting and something important to know related to the whistleblower complaint investigations as well as others. And it is interesting because we have seen, an increase in the number of retaliation complaints that have been filed over the last couple of years. Recent EEOC data shows that retaliation complaints now make up about 56% of the complaints filed with the EEOC. And that has been steadily increasing over the last several years, but it hit a high in fiscal year 2020 at around 56%. We've also seen this in the OSHA context. 11C whistleblower complaints, which is the provision of the Osha Act that provides protection against retaliation. Those hit an all-time high in fiscal year 2020 at 2,539 complaints filed. And that number actually did decrease in fiscal year 2021, but still had claims coming in above 1,800 filed in fiscal year 2021. So definitely a priority and something important to be aware of from the Department of Labor. And then another big focal point for the Department of Labor, and something they have explicitly expressed as a priority in this administration, it's targeting protection of vulnerable workers. This was another priority that was highlighted by the Solicitor of Labor during the conference I attended last week. And she noted specifically, some of the ways that they would target vulnerable workers. And then I also, have included a few here that I think sort of show how the Department of Labor is also prioritizing enforcement efforts on vulnerable workers. So one of the first ways is prioritizing misclassification of employees as independent contractors. I think that this has generally been a focus of the Department of Labor because they see this as a really big issue and something that is happening often. Whether that is always accurate or not is another question, but that's certainly, their perception. So investigating and analyzing the classification of employees as independent contractors, where that issue arises, or where a complaint is made, that is certainly going to be a focus of the Department of Labor and this administration. They are also going to be focusing on the temporary worker population. Again, from the safety and health perspective, temporary workers have been a focus of OSHA for a while. There is specific guidance out there. It is something that OSHA has vocalized as a priority, but I think it's sort of revamping enforcement efforts related to temporary workers and assessing the work conditions of temporary workers, both in the safety and health context, as well as, in the wage and hour context. Altering the standard used for tipped employees and the ability of employers to take a tip credit. I'm going to talk about that in a little bit more detail, but that is certainly sort of another area where the Department of Labor sees vulnerable workers and prioritizing vulnerable workers. And then also related to the heat stress rulemaking, the Department of Labor has expressed that its belief that there's a disproportionate impact of heat-related hazards on vulnerable employee populations based on, the type of work heat hazards often impact. So the heat stress rulemaking has come about, and I'll talk a little bit more detail about that rule later on, but that has come about related to this concern for vulnerable employee population. The Department of Labor has also expressed that it will use the tools available to it to provide protections for immigrant workers. This includes like temporary restraining orders. It also would include, investigation of issues related to this type of employee population. And then also, this targeting protection of vulnerable workers, we've already seen it sort of influence the rulemaking priorities and enforcement efforts from the Department of Labor, but believe that it will continue to do so during the course of the Biden administration. I will now kick it over to Mark to talk about the ban on private arbitration, which we see as, again, sort of related to this idea of prioritizing a vulnerable worker population.
Yeah, thanks, Lindsay. So this just happened last week. I guess it was 2 weeks ago now, sorry. But President Biden signed an act that I guess they couldn't come up with a fancy acronym for. That it seems like most acts are known these days by a fancy, catchy acronym, but this one would be called the IFA SASHA, or I guess something like that. So it doesn't flow very nicely, but it does really change things for arbitration in the workplace. It's the actual title is Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And this amended the Federal Arbitration Act, which has been in place for something like 100 years or so now. Some of you may be familiar with the efforts in the last, 5 to 10 years. There were several states that passed laws to prevent arbitration, forced arbitration of such suits involving sexual assault, sexual harassment. States like California and New York, I think, maybe Washington, New Jersey. I think there might have been a couple others. But those laws were generally preempted by the Federal Arbitration Act. And so this ending forced arbitration of sexual assault act is not subject to the same preemption because it amends the Federal Arbitration Act on a federal level. And that would end the use of forced arbitration in suits involving sexual assault and harassment claims. This had been bubbling around for several years. The Me Too movement provided significant impetus to get this done finally, and it finally was done last month when the House voted by, you can see there, a pretty overwhelming margin, and then it passed the Senate by a voice vote. President Biden signed it on March 3rd, so this has just taken effect. Next slide, please. It is effective immediately, so it is in effect right now, and as you can see, it applies to all disputes related to sexual assault or sexual harassment that arise after enactment. Now, this is one thing to note, is that this is at the election of the person alleging the violative conduct. So the plaintiff, who, if they have signed an arbitration agreement that would otherwise cover the claim related to a sexual assault or harassment, claims of that type, they could go to arbitration. They could choose to have the claim heard in arbitration, but they don't have to. So it's at their option. Most would probably choose to not go to arbitration, if only for the leverage that is brought about with by the public nature of filing a claim in court. And that's what a lot of people objected to in the past several years, especially in the Me Too movement, that the arbitration, that the nature of the claims in arbitration led to their not being public, and that it allowed employers to shield themselves and perhaps their supervisors from public scrutiny. So that's what this act is, to stop that practice. So it prohibits the use of pre-dispute arbitration agreements or class action waivers, and I'll touch on that in a second too, dealing with disputes that, quote, had not yet arisen at the time of the making of the agreement. So even though it applies, right now going forward, it addresses only pre-dispute arbitration and joint action waiver agreements. So any agreement to arbitrate claims that are entered into by the parties after a claim arises would still remain enforceable. Now, I don't know how exactly that plays out. I guess if you had, annual arbitration agreement, or the ability to enter into arbitration agreements annually or something, and paid a little bit extra, then maybe they would cover all claims that had previously occurred. But I don't know if that's worth it or not. But in any event, the ban on private arbitration applies only to agreements that have been entered into pre-dispute. Next slide, please. So some steps that you might consider taking or enforcing here include creating a positive workforce culture, implementing and enforcing effective workplace policies, and providing education and training. This sounds like normal behavior in the workplace, and that's pretty much what it is. It covers creating a positive workplace culture is something that you should be doing anyway, because that's where you get the most productivity from your employees. And this is something that really needs to come from a top-down perspective. So I would encourage that. Implementing and enforcing effective workplace policies, you're going to need to review your standard workplace agreements, particularly any arbitration agreements, maybe even severance agreements, things like that, excuse me, that may have arbitration agreements in them, or agreements to waive class action or joint action or collective action waivers. You need to take a look at all of those and ensure that they're not covering the sexual assault and sexual harassment claims that arise post entering into those agreements. And then provide education and training. Again, this is another step that can help you limit liability, and that's true across the board in the employment arena, as I'm sure most of you are aware. But employees need to be trained to know what the clear rules are, what the procedure is for reporting harassing or sexual assaults, things of that nature. There needs to be alternative means of reporting if it's if it's their supervisor that is engaging in the conduct. And of course, you need to investigate these matters and take them very seriously. But just know that any of the upshot here is any arbitration agreements that previously would have covered these types of claims are no longer going to be enforceable at the option of the claimant. That applies to collective action waivers as well. Let's go to the next slide, please. So now let's talk about recent Department of Labor regulations and regulatory changes. Next slide, please. All right, let's see. So in January 2020, this is when President Trump was still in office, the DOL published a final rule dealing with joint employers called Joint Employer Status under the Fair Labor Standards Act. This took effect on March 16th, 2020. Well, as you know, President Biden was elected later that year, and just about a year after this took effect, as we'll see here in a minute, the Biden Department of Labor determined to rescind this rule. But before we talked about its rescinding, I wanted to lay out for you sort of what it was and what it was seeking to accomplish. Joint employers, as most of you probably know, are individually and equally responsible for compliance with labor and employment laws. For instance, joint employers are subject to the minimum wage, overtime, and record-keeping requirements under the FLSA. And this applies to both so-called vertical and horizontal joint employment. Vertical joint employment generally exists when a worker is employed by one employer, as in a staffing agency or subcontractor relationship, but that worker is economically dependent on a different employer that actually receives the benefit of the worker's labor. That's known as vertical joint employment. And horizontal joint employment is where there's two or more entities that separately employ the same worker for different hours within the same work week. Let's go to the next slide, please. Let's talk a little bit about for vertical joint employment. The rule that was adopted in the Trump administration had a 4-factor test to determine an employer status, joint employment status, which assessed whether the potential joint employer actually, and they looked at these 4 steps: hired or fired the employee, supervised and controlled the employee's work schedule or conditions of employment, determine the employee's rate and method of payment, and maintain the employee's employment records. It excluded other factors that were not indicative of a potential joint employer's control. And it deviated from previous interpretations of the rule in that it required a potential joint employer to actually, you might have noticed I emphasized that word actually before the 4-factor test, whether they actually exercised control over the employee or not, because previous interpretations were broader and they considered merely whether the right to control existed, as opposed to the actual exercise of control over the worker at issue. That was a pretty big and significant change. Next slide, please. So as I mentioned, the Biden administration came in, and I think it was around March of 2021. So shortly after President Biden took office, they announced that they were looking at withdrawing the joint employer rule that had been promulgated during the Trump administration. And in July of last year, they actually carried that through and rescinded the joint employer rule. That leaves sort of this empty space, which, you know, it's the joint employer rulings from various courts have existed for some time. And so this isn't, you know, the absolute worst thing in the world. However, the Trump administration rule was generally viewed as more favorable and more concrete for most joint employer situations. And that emphasis on actual rather than just potential control was a key. Now, without any new rule, and it's not clear whether the Biden Department of Labor will issue its own new joint employer rule, or we'll just wait and see and leave it up to the courts. That's not clear at this point. But so now we're left with just sort of the hodgepodge of sometimes inconsistent tests that different courts followed. And sort of the bottom line there at the bottom of this slide is that there's less certainty for employers under the rescindment of the Trump era rule. I guess overall, the final rule certainly makes it, this final rule rescinding, withdrawing the joint employer rule, makes it more likely that an employer will be considered a joint employer under the FLSA. So that's something that needs to be kept in mind as we go forward. Now, I did see I think there was a question in the chat about tip credits, and I think that you might be happy to know that I think Lindsay is going to pick up that right now.
Yes, thank you, Mark. So another significant departure from a rule established during the Trump administration was a new rule that has been passed during the Biden administration related to when an employer can take a tip credit. So before I sort of delve into the rule and the changes that it made, for a little bit of context, under the Fair Labor Standards Act, a tip credit is when an employer can pay a tipped employee some amount below the minimum wage because the tipped employee makes up that amount in tips. So that's sort of the logic behind it. But the regulations implementing the Fair Labor Standards Act, or the FLSA, limit when an employer can take a tip credit and provide specific circumstances for when an employer can take a tip credit. And during the Trump administration, a regulation was passed that broadened what had been the general standard for when an employer could take a tip credit. And what it did is it permitted employers to take a tip credit for any time spent performing duties related to a tipped occupation. And part of the justification for this was that the prior rule, which some of you might be familiar with and will be familiar with after we talk a little bit more about the new rule, which some refer to as the 80-20 rule, made it limited when an employer could take a tip credit based on sort of this percentage of time that they were spending doing tipped work versus what the Department of Labor had classified as, non-tipped work or non-tip producing work. And so during the Trump administration, they passed this new standard that they thought would ease an employer's ability to determine what constitutes work for which they can take a tip credit, because it wasn't so focused on a percentage of time doing this task versus a percentage of time doing this task, and having to sort of track the time to be able to do that. And that had been a real criticism of the prior rule. So in October 2021, the Department of Labor did pass what it called the tip regulations under the Fair Labor Standards Act rule, also known as the dual jobs rule. And that became effective on December 28th, 2021. And the new rule really does two things. The first thing that does, or the first main thing that it does, is it withdraws part of the prior rule that was passed during the Trump administration, that again had created that broader standard, the ability to take a tip credit for any time spent performing duties related to a tipped occupation. So it withdrew that broader standard and put in place the new standard that is akin to what had been in place during the Obama administration and in prior administrations, this concept of the 80-20 rule. So as sort of a starting point, under the new rule, an employer can take a tip credit for all tip producing work, and the regulation actually in the actual regulation provides multiple examples of what would be considered tip producing work depending on the position. And then they can also take a tip credit for work that directly supports tip producing work, provided it is not performed for a substantial amount of time. So now under this new standard, if an employer wants to take a tip credit, either the employee has to be doing tip producing work or work that directly, and directly is an important term, again, sort of narrows when an employer can take a tip credit and the type of work that is considered appropriate for a tip credit, and that work cannot be performed for a substantial amount of time. So the next slide sort of breaks this down a little bit further. The regulation does define substantial amount of time, and it actually defines it in two ways. So again, going back to this 80-20 rule concept, a substantial amount of time is any time that exceeds 20% of the hours worked during the work week, or, and this is a new component to the rule that was not in place in the prior iteration, or if it is performed for a continuous period of more than 30 minutes. So those are sort of the two main standards that an employer will have to use to determine whether an employee has been performing this work that directly supports tip producing work, but is not actually tip producing work, to determine if they can take a tip credit. And so we did provide an example here of how this could work. If a server works 40 hours per week, but spends about 9 hours cumulatively doing non-tip producing work, so that work that directly supports the tip producing work, but is not considered tip producing work in and of itself, the employer would be able to take a tip credit for 8 hours of that 9-hour period, because 8 hours is 20% of the hours worked during the work week. And then kind of going to that second component of the substantial amount of time definition, if the server were to spend 45 minutes straight cleaning glasses and wiping down the bar at the end of a shift, so when they're no longer sort of performing tip producing activities, they're no longer serving customers, they're now sort of cleaning up the area. If they do this for 45 minutes, then no tip credit can be taken for that 45-minute period, because it has now entered that substantial amount of time that would not constitute work appropriate for a tip credit. So again, sort of transitioning back to the pre-Trump rule, it does, the Department of Labor, in explaining this transition, did assert that, the tip producing work and the non-tip producing work that directly supports it are generally being performed together. And so it shouldn't be the case that an employer has to sort of, track super closely the amount of time spent doing each individual task. But at the same time, it is definitely a narrower rule. It definitely sort of sets out strict boundaries for what's considered substantial amount of time. So there will still be some requirement to, track what time is being spent doing what activity. So it is a significant change from the rule that was passed toward the end of the Trump administration. And, as it goes into effect, I'm sure we will see case law surrounding this and, see more specifically how this rule is going to be interpreted. Although, the first part, the 80-20 split of the hours worked during the work week, there's already case law and guidance on this that will just come back into play now that the rule has changed. Next slide. And then beyond the wage and hour issues that Mark and I discussed, there is also significant rulemaking from the Department of Labor on the safety and health side. Some of you, may have been participating in some of our webinars over the last many months now, but more recently as well. You'll know that the emergency temporary standards that were passed, both for healthcare and then the one that applied generally, the vaccine or testing ETS, are both no longer in effect. The vaccine or testing ETS was, actually withdrawn after a Supreme Court decision questioning OSHA's authority to, be able to pass a rule like that. But the healthcare emergency temporary standard that went into effect in June 2021, OSHA chose to revoke the requirements of that temporary standard around that 6-month window, at which time an emergency temporary standard is supposed to no longer be in effect, at least from our perspective. But it did announce its intent to adopt a permanent standard for healthcare. So a COVID-19 standard specifically for the healthcare industry. And when the emergency temporary standard was published back in June 2021, per the process for that, it automatically became a proposed rule. And so that sort of started this rulemaking process that OSHA is now going to be pushing along to try to get to a final standard. As I said, we heard some discussion about this last week, and the Assistant Secretary of Labor, Doug Parker, who is the head of OSHA, stated that OSHA is working diligently on this effort for both a healthcare standard and a general infectious disease standard, which I'll touch on next. And beyond that, so we do think that this is forthcoming. There'll still be some time as they're sort of developing the rule, but this is something that we're likely to see. And then beyond sort of this rulemaking effort, there is also going to be continued enforcement efforts from OSHA related to COVID-19, particularly in the healthcare industry, through its national emphasis program. There'll also be general enforcement efforts for all industry that OSHA would be pursuing under the general duty clause. So just something sort of, particularly if you're in the healthcare industry, something to be aware of, this rulemaking in place. And then finally on the next slide, the infectious disease rulemaking. So this is an effort separate and apart from the COVID-19 healthcare standard, but definitely some overlap here. And OSHA did announce in the regulatory agenda and then has also publicized more widely that there is a proposed rulemaking for a general infectious disease standard. This has actually been in the works for quite a long time now, several years. But because of COVID-19, there has been more priority given to this particular standard and the development of this standard. This infectious disease rulemaking is intended to cover healthcare, similar to the other standard, the COVID-19 specific standard, but it is also intended to cover high risk environments. And that could certainly include environments like meatpacking industry work environments where employees are working, closely together generally. And those are conditions that OSHA considers to be, sort of the types of conditions that could allow for a quick spread of an infectious disease. It is intended to cover both long-standing infectious diseases as well as emerging ones like COVID-19. So the intent of this standard is to address those diseases that we are already aware of, as well as to sort of be proactive and have a structure and framework in place should something similar to the COVID-19 pandemic happen in the future. The fall 2021 regulatory agenda projected April 2022 for notice of proposed rulemaking on this effort. Those are very gray, certainly not something that Osha will necessarily stick to. We see those proposed dates pushed often, but I can say from what I've heard that this is also a priority for Osha. So I do think that there is some push here to get a notice of proposed rulemaking out related to an infectious disease standard. Next slide. And then finally, before I kick it over to Mark to talk a little bit about some changes we've seen in the context of the National Labor Relations Board, we did want to mention a couple other regulatory actions that are in the works because we see them as pretty significant and something that employers should sort of keep an eye on going forward. The first is the rulemaking for white collar exemptions. So this is, I believe, at the notice of proposed rulemaking stage. Through this rulemaking, the Department of Labor intends to evaluate whether the threshold salary level for exempt employees should be updated again. I think all of us are probably familiar with the updates that were initiated and then finalized between the Obama and Trump administrations. Currently, the minimum salary threshold for exempt employees under the Fair Labor Standards Act is $35,568. So that is the threshold salary that an employee would have to make to be considered exempt under the Fair Labor Standards Act and exempt from certain requirements of the Fair Labor Standards Act, along with the duties test, which is also part of the analysis to determine an employee's exemption. Interestingly, when the Department of Labor promulgated the rule initially, back at the end of 2016, it had actually raised the minimum threshold level from $23,660, where it had been for quite a long time, to $47,476. And that minimum threshold amount was struck down by a federal court because the judge determined that such a significant increase actually rendered the duties test meaningless. So it'll be interesting to see how that decision and how that analysis plays into the Department of Labor's rulemaking efforts to now consider raising the threshold level again, and how it might impact if they ultimately determine that the threshold level should be raised, how high it should be raised, and what that amount should be. And the threshold level for exempt employees has not changed since that $35,568 threshold was set during the Trump administration. So there is active rulemaking on this right now. There'll certainly be opportunity for industry to weigh in on this issue. So something to sort of keep an eye on and actively participate in to the extent you can. And then the next rulemaking effort that we just wanted to highlight briefly during this presentation because of its potential significance for employers is the heat illness prevention standard. So OSHA has initiated a process to eventually have a heat illness prevention standard. It is at the very, very early stages. They just published the advance notice of proposed rulemaking, which is kind of the first step in the process toward getting the specific regulation in place in October 2021. Currently, OSHA relies on the general duty clause to enforce and inspect for heat-related hazards and to issue citations for any heat-related hazards it finds during an inspection. But this effort would create a specific standard that OSHA could use in that effort. They accepted comments related to the advance notice of proposed rulemaking until it closed in January. I believe it was January 26th that the comment period closed. So OSHA is now at the point where it is considering the comments that were submitted, kind of analyzing what sort of standard would be appropriate in this context, and the scope and different components of the standard. The advanced notice of proposed rulemaking included, I think, over 100 questions that stakeholders could respond to and information that OSHA was looking for. So it'll definitely be a process to review the comments and sort of come to a more solidified form of the rule. And then on the next slide, I won't spend too much time on this, but it is just sort of a quick overview of the main topics that OSHA was looking to assess through the comments it received related to this advanced notice of proposed rulemaking. The scope of the rule is definitely an important one. How this rule should apply, what employers this rule should apply to, what conditions this rule should apply to, what industries or workplaces. That is definitely going to be a big one. And then also, I think, a really important thing to OSHA in this effort is, what employers are currently doing to address these hazards. Like I said, they are using the general duty clause to cite employers in some cases for heat-related hazards. So OSHA has asked for information about what employers are currently doing and how some of these main topics are being addressed or should be addressed in a rule like this. So with that, I will turn it back over to Mark to talk about significant changes from the National Labor Relations Board. And I think, generally the changes that Mark is going to be talking about are those that can affect both unionized and non-unionized work environments. So I think a really helpful discussion as well.
Yeah, thank you, Lindsay. And you're right. That's why we included these slides, is because they apply to non-union employers as much as union employers. There was a question in the chat about the joint employer rule, and someone asked whether there was a Texas federal court decision on Monday that voided it. I don't think so. I hadn't heard it, but my family and I have all been diagnosed with COVID this week, and we've been sort of hunkered down here. But I don't think there was anything like that. There has been some litigation that was against the Trump era rule back in 2020, and I think a court in New York struck down parts of the rule. And then I think after President Biden rescinded the rule, that the Second Circuit, which is the appellate court that's over New York, mooted the entire case and said that the rescindment of the rule had mooted the case. And so that's the only litigation that I'm aware of. If there's something that's came out this week, I apologize if I missed it, but I wasn't aware of it. And I don't think that anything like that has come out, but we'll put it on our blog if there is, I'm sure. So let's talk about the NLRB here quickly and what has happened there. Jennifer Abruzzo was confirmed as general counsel of the NLRB last July in a 51-50 vote. 51-50 was a great album by Van Halen back in the wild days of my youth. But that margin was pretty significant here for Ms. Abruzzo, because there was significant opposition to her from employer related groups, and some people pushed back against her, thinking that she had something to do with the termination of the prior general counsel and that she was seeking his job. But I don't know about all that. But anyway, she did get through, and the narrow majority that confirmed her didn't stop her from getting to work right away, because within a couple of weeks she issued a memorandum, which you see there in the slide as General Counsel Memo 2104, that laid out various matters that the regions, the NLRB is broken into different regions around the country, and these regions had to submit these different questions for advice from General Counsel before there's any decision made. Two of the top targets that were mentioned in that memo last August were employer handbook rules and confidentiality provisions. And as Lindsay mentioned, perhaps your ears perked up, because this those were prime targets during the Obama administration from the NLRB, mostly for non-union employers. And it looks like it may start swinging back that way again. The National Labor Relations Board is now back to a Democrat appointed majority, 3-2. And the NLRB is famous for its policy reversals as administrations change. And that looks to be the case here. Following on that memo last week, I think it was like March 7th or 8th, the general counsel filed a brief in a case called Stericycle, in which the members of the board had invited the public to submit briefs commenting on whether they should change the standards for employer handbook rules or for confidentiality provisions. And the general counsel took that opportunity to weigh in and say, yes, the board's prior standards, those that prevailed during the Obama administration, should be once again put into effect by the board. This followed invitations from the board on a couple other matters that it may be reversing. The board invited briefs to reevaluate its standard for determining appropriate bargaining units in December, and also later in December, invited briefing on whether it should reconsider its standard for determining independent contractor status. But I wanted to talk mostly about these two because of their implications for non-union workforces and because they were so recent. Next slide, please. So the prior standard for evaluating workplace rules was Lutheran Heritage. And under Lutheran Heritage standard, the maintenance, even having a neutral work rule, would violate the National Labor Relations Act if the employees would reasonably construe the rule to prohibit union and other protected concerted activity, usually known as Section 7 rights. And that standard would reasonably construe was the standard that prevailed under Lutheran Heritage. And as I mentioned, during the Obama administration, the board relied on Lutheran Heritage and that reasonably construe standard and invalidated numerous rules for many employers, most of which were non-union. And many employers found that their rules and policies that they had in their employee handbook and elsewhere were invalidated under this standard during the Obama administration. A lot of people felt that the standard, certainly its application, failed to give any proper weight to the employer's legitimate business interests in maintaining those rules, but that's the way that it was. Next slide, please. In 2017, in a case called the Boeing Company, the board overruled Lutheran Heritage, and then in a later case, I think it was called LA Specialty Produce, I think, came out with 3 broad categories for evaluating the lawfulness of workplace rules. And that board just said, there's lawful rules, there's unlawful rules, and then there's rules that require us to scrutinize them individually. And so it was those 3 categories. You're either lawful, you're unlawful, or we need to look into it. This seemed to many employers to be a much, certainly more employer-friendly standard, in that you had notice right up front, based on generally on the subject of the workplace rule, whether it would be lawful or unlawful. But the post-hearing brief that the new general counsel just filed last week recommends to the members of the board that they go back to the Lutheran Heritage standard, and said that Boeing was more complicated, less predictable, and much less protective of employee rights. Next slide, please. It's not clear whether the board will go to the prior standards or under Lutheran, or whether they will come up with their own novel approach. But the general counsel suggested numerous tweaks to the Lutheran standard. And one of those was that rather than an employee that would reasonably construe the policy to violate his or her Section 7 rights, the general counsel suggested that it would be invalid if an employee could reasonably construe. And that obviously seems less employer friendly, more employee friendly. The brief submitted by the general counsel also suggested that the board should not presume that employees are aware of their rights under the National Labor Relations Act, but should presume that employees will interpret a rule to be restrictive of their rights under the National Labor Relations Act. Basically, they're advocating for a much more employee-friendly standard, and that's likely to be the case, regardless of whether the board goes back to the Lutheran Heritage Standard or comes up with something on its own that's either as employee-friendly as Lutheran Heritage, or more likely more friendly to employees. So be on the lookout for that, and pay attention to that Stericycle case, and we'll see what the new board does with that. Next slide, please. This is the last thing I wanted to talk about. This was another change that was recommended by the new general counsel in her brief to the board in Stericycle. Recommended the board to abandon the framework that it has used for evaluating confidentiality rules for workplace investigations. This was the standard that came about in 2019 in a case called Apogee Retail. That case overruled an Obama era opinion. And like I said, these cases go back and forth, and you can see, Apogee overruled Banner Australia, which was an Obama era decision. Trump's board set their standard in Apogee, and now the general counsel under Biden is seeking to swing it back to Banner Australia. But under Banner Australia Medical Center, that called for a case-by-case determination of whether a rule calling for confidentiality during an open investigation was merited. And the employers would argue that they had interests in preserving the integrity of an investigation, and that outweighed employee Section 7 rights, while the Obama administration era board saw it otherwise often. And under Apogee, let's go to the next slide, please. The board held that the employer's restrictions were categorically lawful. So if you had a confidentiality policy and it applied just during the duration of that investigation, then it was just presumed to be lawful. So again, that was more employer friendly. The standard that is being sought by the new general counsel is far more employee friendly. As you see there at the bottom of that slide, she recommends returning to the prior standard under President Obama, and said that the Apogee decision would chill Section 7 rights of employees during open investigations because they might reasonably fear discipline based on a violation of that rule. So we'll see what Stericycle does with that as well. And I think that's all I've got.
The clarification question: anything above 30 minutes is that entire period of time considered non-tipped, or would it be that it's 30 minutes that you can consider toward the tip credit, and 15 minutes of a 45-minute period would be considered, not eligible for the tip credit? Is a summary of the question. And that is a good clarifying question. So originally, when the rule was proposed, it was going to be that whole continuous period could not be counted. But the Department of Labor modified that position in the final regulation and did allow sort of leeway for that first 30 minutes. So the first 30 minutes could be considered toward the tip credit, but any time spent beyond that 30-minute continuous period would not be considered would not be permitted. An employer would not be permitted to take a tip credit for the time that exceeds that 30-minute period. So thank you for that clarifying question. And I think that was those were the questions that we saw, but we certainly, if we miss anything, we'll take a look back through this and follow up if we miss anything else. But you can check out our blogs for additional information. We keep those really up to date. We post on them often. So they are a good resource for any, Department of Labor related changes in the law or enforcement actions, as well as, other issues and changes that we're seeing in the law in other contexts.
Yeah, and Lindsay, I should jump in here real quick. I did just see that other question about required to post a NLR poster. I'm not positive what is meant, but I think it's just you have to post something about the rights under the NLRA. If I'm reading that right, I believe the answer is no. And this is something else that under the Obama administration, the National Labor Relations Board did come out with some sort of a rule, if I remember right, that said that you had to post a poster that set forth employee rights under the National Labor Relations Act. I think that was enjoined, and now it's just a voluntary thing. I don't think that I'm sure it wasn't changed under the Trump administration. I don't believe that it has been changed or that it has been put back into effect under the Biden administration. And so I believe the answer to that is no.
All right. Well, thanks everyone so much for joining us for this webinar today. This is definitely an evolving area. The Department of Labor has been quite active during the Biden administration to date, and we expect that to continue, and we will continue to update you all as those changes happen.